All right, we are going to start off with Senate Bill 881.
So Senate Bill 881, the amendment is to make it into a task force. The task force would consist of a representative of the Anti-Defamation League, representative of the Maryland Chiefs Association, and a representative from the Maryland Sheriff's Association, representative from the State's Attorneys Association, the Public Defender Designee, a representative from the NAACP, 3 senators, and 3 delegates, each appointed by their respective leadership, the president of the Senate, presiding officers, and staffed by the Office of the Attorney General. One thing I don't have is how long it should go. I assume it'll be from June of this year to June of next year?
Sure.
Okay. And the purpose of the task force will be to study the laws relating to and applicable to the practice known as swatting.
And make recommendations.
And making recommendations regarding legislative changes.
Well, we gotta adopt
With
the amendments
amendments.
first, so everyone's okay adopting those amendments? All right. So there's been a motion for favorable with amendments. Seconded. Everyone's okay? All right. Second, we'll go to Senate Bill 879.
Senate Bill 879 establishes a process by which a corporation may ratify a defective corporate act and specifies that a defective corporate act that is ratified in accordance with the bill's requirements is not void or voidable as a result of the failure of authorization. The bill also authorizes a court to determine the validity of any ratification and to modify or waive the bill's ratification procedures. And finally, the bill specifies that the requirements of the bill are not the exclusive means of validating a defective corporate act. And the bill requires that articles of validation be filed with the State Department of Assessments and Taxation to validate a defective corporate act. There is an amendment in your packet that's number 133323/1. This conforms the bill to the version that passed the House. It clarifies some of the definitions and makes other stylistic changes, and additionally, it allows that if the exact date of a defective corporate act is unknown, the approximate date of the act may be used for the purposes of the bill's requirements.
Move the amendment.
Okay. All right. It's been a motion for favorable. It's been seconded. Everyone's okay?
Favorable with amendment.
Favorable with amendment. All right. Watson, we're going to go with Senate Bill 956.
Refresh, Senate Bill 956, as drafted, adds health officers, election administrators, and public employees responsible for inspecting and enforcing housing and building codes to standards, and standards to the list of public officials against whom it is illegal to make specified types of threats. There is an amendment. It is not in your voting packet, but the amendment would effectively strike provisions of the bill as drafted and instead alter the definition of a local official to include the chief health officer for a county.
That's it.
And that's it.
Everyone's good? All right. Motions for favorable on the bill? Sure, yeah, absolutely.
I just have never cared for these kind of bills. I know we're in it, and I would actually, if it was up to me, I would never put us in it. I think I probably voted against adding us in it too. I just don't like, and I've never liked, this hierarchy of we get treated one way, and then the public, everybody else gets treated another way. I just don't. I never cared for that. And so, but this makes it tough because now they want to add people, and if I vote against this, I'm voting against adding health officials for something that we have. But for the record, I don't agree with that we have it in the first place. I just think everyone should be treated the same, and I don't like the special carve-out. No, I mean, I don't think anyone should be threatened. I mean, I just, in general, I think everybody.
Proceed.
Yeah. Golf carts are much different and more serious.
And the traffic
issue.
cameras. All right. All right, so the bill passes unanimously with amendment. Okay. Next, we'll go with, this is also not on this list, it's Senate Bill 884, that's Senator Watson.
An amendment in your packet for Senate Bill 884. 884. That's not the right amendment. So, the amendment in your packet ending in 127, it adds new language which specifies that the bill does not apply to an obligor who has judicially been determined to be voluntarily impoverished. The bill then goes on to specify that the revocation of a driver's license for an individual who is out of compliance with child custody payments, that their driver's license may not be suspended if their income is not greater than 300% of the federal poverty level. And then
Yep, we're good.
Sure. So the amendment ending in 127, it just adds language specifying that this bill will not apply to an individual who has judicially been determined to be voluntarily impoverished. That is the amendment that was requested favorable with amendments in written testimony and also submitted at least one individual oral testimony. So this has to do with the suspension of a driver's license for child support arrearages. So under this bill, if the individual is not voluntarily impoverished, their driver's license cannot be suspended if their income is not greater than 300% of the federal poverty level.
What does that amount to in today's number?
It's roughly around, I think it's like 30,000, give or take, maybe 32. What was the 300%?
What is that in number? What is that income? What does that mean?
So right now, the 2022 federal poverty level is 13,590.
That's
So-
100.
Times 3, right.
Something like that?
Or 40,770.
On line 7, just after line 7.
Okay, I can make that correction.
Yeah, that's good.
I just need to put this in, can you just put this in context? So, I never knew exactly how this works. So, somebody's ordered to pay child support, and then somebody tells MVA, this guy's a scofflaw, he's not paying his child support. Who does that?
Sorry, can you repeat the question?
Sure, I'm just trying to understand the bigger picture here, take a step back, see how this all works. So this, somebody's not paying their child support, right?
Correct.
And then the person who's not being paid their child support, then they have to ask the MVA not to impose this penalty, right?
So the way it was submitted in, during the oral hearing is that this is an automatic system that the court, or that the MVA has in place. So as, when the individual becomes in arrearages, it's automatically done continuously. So an individual can get an exception under current law, but then they're still under in arrearages, so it can automatically happen again and again, is how
But
it's
how does the
presented to
MVA know
court.
that? How does the MVA know they're in arrearage?
I do not know how they are notified.
Okay,
And the information
okay.
automatically.
All right, and then it says this does not apply, the second part, so I got it. So they've been determined to be determined to be,
Voluntary impoverishment?
who has been determined to be voluntary. Okay, we're saying under that section, if you're voluntarily impoverishing yourself, you don't get this break, right? And then if you do get this break, then you're 300% of the poverty level. And then who makes that determination? Is that back at the Child Support Bureau? Do they make that determination?
Who what?
We're trying to see practically how this works.
They would under this bill.
Okay. And then they're the one that would then sell MVA, cease and desist.
Right.
This guy has no money. And it's not because he's voluntarily impoverished, right?
Correct.
Thank you.
So, yeah, so right now they're supposed to get a notice, and when they get that notice, they'd be able to challenge it, saying that they are 300% below.
Correct.
This is only the suspension of a driver's license.
So when the time comes to renew, the fact that the person hasn't paid child support can prevent a new license from being issued, right?
This, yeah. This bill's only dealing with suspension. I don't,
Okay, so the implication is that renewal is its own special deal. And you'd have to have a separate bill to prevent a license from being, to override the general rule that you're not going to get your license, a new license or renewed license, if you're not up to date on your child support.
because this is just the section that's dealing with suspension. I don't want to alter the previous.
Get their license renewed, but then it would immediately become suspended through this process.
Hey, Josh, do you know anything about this? Do you know what's the fall section?
The Attorney General, 2 or 3 years ago, I think you were there, and the whole deal was you can't suspend a license, but when it comes up for renewal, if you haven't corrected the problem, you don't get a renewed license. And you can't send someone to jail on it, because people are being sent to jail for driving with suspended licenses. So we didn't want to suspend the license, but when the renewal time came, unless they'd fixed the problem, they couldn't get the license renewed. That's my recollection.
So, right now, what is the current law now? So if right now, and this is for, right now, or whoever can help, you can get your license suspended if you're 60 days or more behind in child support. And then they can issue you, they may issue you a work-restricted license or a work-restricted privilege to drive. So then this does away with that for people that are, does this do away with that?
No, this just
Says
is
you-
saying
you can't-
your driver's license cannot be suspended. So you're not getting a provisional or a
work
specialty
restricted.
work-restricted license. You still have your normal driver's license.
So it does do away with that.
So it does do away with
essentially.
it for people making 300.
A work restricted
It wouldn't
license.
apply to them.
It wouldn't apply to them, that's what I'm saying. The work restricted thing would not apply to them.
Their driver's license would in no way be any different or
So it would
altered
not
in any
apply to
way.
them.
Correct.
Alright, so the question then is, why is the work restricted license not good enough for poor people?
That was based on the testimony. If you don't have a driver's license, trying to get that
Yeah.
evidentiary evidence that you are trying to apply in the process of looking for work, that this was covered in the hearing for examples for someone who had a job work connection program that he was running, of saying that this exception didn't cover all the instances for individuals trying to
Got
get
it,
to work.
that's instructive. But would that not, sorry, go ahead.
Why do you have to have a job to get a work restricted license? Why isn't the work restricted license just provided?
I don't know. I just know from the testimony that the committee received that there are instances of individuals who are ineligible to apply for certain jobs because they don't have that ability to get that driver's license restriction.
Senator Watson.
So one thing I just wanted to say is that when a police officer pulls somebody over, they have no way to determine whether it's a work-restricted license or not. You know, so those types of things are never really enforced.
Everyone's okay to adopt the amendments? All right. Thanks. Do you have another question, or I'm fine? Yeah. Oh, sorry, yeah. Further debate? Senator Watson, want to make a motion?
I move to accept everything that I've put together.
That's a good motion.
So this is on the amendment, right? This is on the amendment?
No, we adopted the amendment.
Okay. I move favorable on Senate Bill 884
With amendments,
with amendments.
Wes seconded, okay. Bill is before you with amendment, further discussion? All right, do we need a roll call?
I think I'll just vote no on it. I'm unsure.
Okay.
Yeah, I was gonna say, that's what we were just talking about. I'm pretty sure the police do know.
So Huff and Bailey are no. Anybody
Okay.
else? Kathleen, you're good?
All right. There you go. Senate Bill 347.
So Senate Bill 347 is a local Anne Arundel County bill. There are two amendments in your packet. The bill creates alternative provisions that only apply in Anne Arundel County for the process of eviction. So under the bill itself, it provides that if a landlord is going to evict the tenant, they must provide the tenant a 14-day notice with the estimated date of eviction, and the bill specifies the information that must be included on that notice and provided to the tenant. There also is a rebuttal presumption that the tenant was notified if the landlord provides certain information. And then when the individual who's executing the warrant, they are then prohibited from removing any of the personal property from the premise. The tenant under the bill will have a 24-hour period to re-access the unit and take their personal property with them. At the end of that 24-hour window, the property is then deemed abandoned, and the bill sets forth how the landlord may dispose of the personal property. So there are two amendments in your packet. One of the amendments is from Senator Beidel. This amendment specifies that if a sheriff who executes the warrant while walking through the premises, this is the amendment ending in 220. If the sheriff is walking through the premise and in plain view, they observe controlled dangerous substances, a firearm or ammunition that is illegal to possess, they may seize it. This is current common law, so this would already be permitted without this amendment. The other amendment in your packet is ending in 422. So this amendment makes two different changes. The first change is appearing on page 3 of the bill. So this alters how the landlord is required to provide notice to the tenant of the eviction date and the information that is required. So currently, the bill requires it to be sent by first-class mail with certified mailing or end posting of the notice on the front door of the leased premise. This bill, as amended, would also require it to be either, if the tenant elects, an email, text message, or through an electronic portal. And then if the tenant, or the landlord, wants to get the rebuttable presumption that the tenant was notified under the bill, page 6 after line 8, it specifies that the landlord would need to show evidence to the court that they in fact informed the tenant through these electronic means.
So the story I get is a little different, that in terms of the notification, that there would have to be sending the notice by first-class mail with certificate of mailing. That would have to occur in all cases. And then there'd have to be a second notification, which would either be posting the notice on the front door of the leased premises, or, if elected by the tenant, sent by electronic delivery. I didn't get in the forms of electronic delivery. Is this a problem? An email message, a text message, or through an electronic tenant portal? Is that okay? What's that? Okay. Okay.
That
yes.
was pulled from bill language from last year that was
Yes.
passed by
All right.
JPR.
So I'm told that language is okay, but we need to make sure that the notice has to be sent in every case by first-class mail with certificate of mailing. And then there has to be a second form of notice, which is either posting the notice on the front door of the leased premises, or, if elected by the tenant, sent by this electronic means.
Okay, so to do that, on page 3 of the amendment, so this is the amendment ending in 422. So page 3 of the amendment, line 8, I would insert and. And then I would say, I'd make 2 Roman I, so, and posting the notice on the front door of the leased premise, or, and then the ones listed under 3.
Yes, that's great. Thank you.
We are on 347.
And then, have you covered the sheriff yet?
What portion of the sheriff?
Well, the agreement of the advocates on both sides is that the tenant would have the right to come back into the premises within 24 hours after being put out. And the sheriff would have to come back with the tenant and admit the tenant to the premises and stay there while the tenant is in the premises, and then lock up the place after the tenant leaves, having removed the tenant's stuff.
Was not part of the final amendment.
Okay, well, we need to amend it, because that's what the parties have all agreed to. That's part of the consensus agreement.
Yeah. Did the judiciary go along with that too? Yeah.
I don't think they've been consulted.
Well,
The
I mean,
judiciary is opposed to the bill as introduced and as amended because it creates a special provision specific
Yeah.
only to Anne Arundel County.
yeah, because the judiciary tries to run a statewide process, which includes notice and double notice, and sheriff serves it. We don't have private processors serving it. It's the sheriff serves them all. They serve the initial complaint. They serve the warrant of restitutions, so they can actually know that somebody was served, that was actually posted. You don't rely on a landlord to post it. They actually post it. I mean, this is,
The bill's no longer before us for consideration. Let's talk something else.
That's a hold.
That's a hold.
This other amendment has problems too. There's a thing with guns and drug money, and then say the depletion season.
What are you doing with 49 right now?
49? Ooh, okay.
So just as a quick refresh for the committee,
Hold on. What does he want to do with it first?
Yes.
I just want to, for the record, I just want to know that I do agree with Senator Carter on this completely.
Where does Senator Carter stand on this?
She wanted a study group.
Oh,
So you,
It's kind of a mess. There's just so many different components, so many different statutes. We need to,
Yep. Senate Bill 704, as drafted, makes changes to the provisions of Chapter 597 of 2021, under which a pretrial defendant may not be required to pay a private home detention monitoring agency's fees or pay for a device or global positioning device under specified circumstances. So as drafted, the bill would specify that the judiciary, rather than the state, must provide the payments for these costs and fees, and alters provisions and expressing the intent of the General Assembly regarding funding, and extends the termination date for the work group on home detention monitoring. So you have an amendment in your packets. That's number 203823/1. So under the amendment, it would revert to being the state that was responsible for paying the costs and fees, and it would require that the payments would only continue so long as there was federal funding available for those payments. And it would extend the work group by 2 years instead of 4 years.
I just want to speak on behalf of the bill and its amendments, and also just give some context for what is going on here, because it's a really important bill. So this committee chose a number of years ago to get rid of cash bail because it's inappropriate to jail people because they have lack of means, and that was the right policy decision. But what happened was that shifted the burden to defendants to pay for their own home monitoring. Most defendants, so GPS monitoring is a good thing. It allows people to stay out of jail while ensuring public safety, to make sure that police know where these defendants are, and should they abscond, that the judiciary knows where their defendants are. So this is a positive development, because otherwise these folks would be behind bars pre-trial. They are presumed innocent, and so the GPS monitoring program is a solid one. But shifting costs to people is inappropriate. It was the exact policy we were trying to get rid of with bail. And so we needed to figure out a mechanism by which we could fund the payment to the GPS monitoring companies which manage this program. And so after bail reform, I put in a couple bills, and now Senator Heddleman has taken the lead on this to make sure we have a mechanism by which GPS monitoring is paid for. Last year, we passed legislation establishing a task force to figure this out. But in the meantime, set up a system by which the judiciary would pay for GPS monitoring themselves for indigent defendants, only indigent defendants, utilizing federal funds. The task force, which presumably would have included Senator Heddleman and I, was never put together to figure this out because the second floor refused to appoint members. It's unclear why the second floor refused to appoint members. It wasn't political. We actually, to this moment, have no idea what occurred there. And so what this bill does is it maintains the status quo temporarily and reestablishes the task force to figure out. So we don't want the judiciary to the judiciary opposes paying for this in perpetuity. And they're right, they shouldn't pay for this in perpetuity. But in the meantime, they can keep doing what they're doing already until the task force figures it out, and that's what this legislation does. So, sorry for the long explanation, but
Task force.
I'm sorry, I don't, to be honest, I don't even know the distinction, but work group.
So I would just wholeheartedly agree with the vice chair. This is a short-term fix to a longer-term problem that needs more analysis. I have been in touch with Judge Morrissey. The judiciary is not happy in this particular role. However, I will say they're, by all accounts and all parties, they're doing an excellent job. So we don't want this to automatically sunset. If we do nothing, it will by August or so. And so the parties are getting their monitoring paid for. The companies have not yet been paid, but it is in the pipeline because of some technical issues with federal government funding pass-through. They will be. So everybody is in agreement, with the exception of the judiciary, that this should continue at least until the federal funds run out. And then we will look, hopefully the work group will come up with some longer-term solutions to this challenging issue.
My question is, when are the federal funds expected to run out?
So it's $5 million. It's a good question. We don't know. There have been about three, at least the city numbers, I believe, are 300 a month. Christopher is here, but 300 or 400 a month. And the home monitoring folks charge roughly $300 a person. So we're about up to under $500,000 has been expended or assigned so far out of $5 million. So I don't know the answer to that, but we could do the math. And that's just the city. So I don't know for sure. Don't know for sure.
Thank you.
Thank you, Mr. Chair. As I read the amendment, we're now putting this responsibility of paying for it on the state. Maryland judiciary is taken out of it.
So this mirrors language that was in last year's bill. Now, it was the state, but in another section it says contingent upon federal funding being available.
Right. So
So
the final result is the state's going to pay for this with federal funds.
Correct. That's what's
And-
happening.
And judiciary should withdraw its opposition because we're not requiring them to pay for it anymore.
Correct.
All right.
But that is not the case.
What?
That is not the case because they have to administer it. They don't have to pay for it, but the administration of it is something that they are not happy about.
Okay, fine. I support the amendment. I'll move favorable on the amendment.
Just a quick question. What? I mean, this is pretrial release. Why wouldn't it be division of parole and probation? Why would that be the judiciary? I mean, aren't they the ones that issue these things?
It's just where it was housed last year. It's where the bill last year put it.
Okay. I mean, I understand the
They would agree with you.
judiciary's position that this ought to be parole and probation's providing these things. It's them. And judiciary's out of the, I mean, they're like the middleman here, so it doesn't make a lot of sense.
They have to be involved, and they're doing it now. So I get you, but
Okay.
that's where we are. Yeah.
Now the bill's before you,
In favor.
as it's been seconded. Everyone's okay? Okay. Okay, so
I will say he.
Huff and
I'll show
Castley
you
are no's.
texting. No, I
and-
don't want to piss him off either,
and
and he's
Bailey.
been trying, but.
Jackson is.
In all fairness, I would like it, I guess, on the record that
You could-
did ask that the judiciary no longer run the program after a date certain or when the money is out.
That's fair.
I don't know if we can do that, then they will drop their opposition. But
We just leave it for another year and deal with it.
I'll leave that to you.
All right. All right, let's do Senate Bill 613.
Wait, I'm sorry, did we vote?
We passed it.
Perfect.
This is like an art auction.
We were still chatting.
You gotta be quick.
Gotta be
you know?
quick.
Go, sorry.
It's like,
You can put me in the, whatever, 613. Whatever bill that was, I'll do whatever you want.
Senate Bill 613 establishes requirements and procedures, or as drafted, establishes requirements and procedures for the non-consensual towing of certain commercial vehicles at the request of state police, and requires the state police to make publicly available, upon request, a list of qualifying tow companies used by DSP, and requires DSP to adopt regulations. There is an amendment in your packet. This is number 893622/1. That makes a number of changes to the bill as drafted. First of all, it replaces the term non-consensual towing with police-initiated towing. And it provides that instead of the state police setting rates that companies are required to use, they would have to set their own rates but make those rates publicly available. And it requires participating tow companies to ban the use of per-pound billing by October 2022. And in the case of a genuine dispute between a vehicle owner and a towing company, the towing company would be required to release cargo immediately on the submission of proof of ownership and a letter from an insurance company stating that the cargo is covered for a sufficient amount to cover the claim or accident that resulted in the towing. Or if the coverage is not enough, a guarantee from the company that owns the cargo that it would cover the cost. And it would require, in the event of a genuine dispute, that a towing company release a vehicle to the vehicle owner upon payment of 20% of the disputed invoice. And finally, it removes the requirement that towing companies cease charging storage fees upon a demand for repossession from the vehicle owner.
Thank you, Mr. Chairman. So I can't tell you how strongly I believe in this bill. The majority of towers in our state are good actors, but there are some towers who are bad actors and are using the current setup in order to exploit truckers who have broken down on the side of the road and keep their cargo hostage until the truckers pay an exorbitant rate. So, you know, in basic economic theory, two parties come together to contract and they agree upon a price. That can't happen in an emergency situation where you have a large 18-wheeler broken down in the middle of Route 50. And so what happens is there is a list that the state police calls, and they just literally go down the list. And if you're a trucker, and these guys aren't making a lot of money. A lot of these truckers are independent truckers, and they're small business owners, and they break down in the middle of the road. They don't get to choose the person who tows them. Now, again, most of these towers are good actors, and they do really dangerous work with very expensive equipment. They deserve our respect for the dangers that they face, and they deserve to make a profit because they're businessmen too, and they deserve to be able to pay for their rigs, which are very technical and very expensive. But what is happening is the owner of the truck has to pay whatever fee the tower charges them. And there is no dispute resolution process when this happens on state roads. And in the meantime, while the dispute is happening, the bad actors in the towing industry take the cargo hostage. A lot of the times, the owners of the truck do not own the cargo. The cargo is owned by a third party. And so the trucker has agreed to take the cargo from one place to another, and suddenly that cargo is impounded by a tower who is charging exorbitant prices. There is a solution. If the accident that I described on Route 50 happens on an MDTA facility, the MDTA has a regulatory process by which rates are set and disputes are settled. Everyone is happy with that system. So if it happens in the tunnel, that's what happens, and everyone thinks it's fair. No one complains about that system. The towers don't complain about it, they participate in it. The truckers don't complain about it, they're breaking down in those MDTA facilities just like they do on Route 50 or 495 or 97 or any other state road. And so the goal of the bill is to essentially mimic the MDTA system for state roads. Local roads, this wouldn't have any jurisdiction. The towers and the truckers have met multiple times on this bill, and I must express disappointment that the towers haven't really given much here. But the truckers have. They've agreed to put down a 20% deposit to get their trucks back and resolve the dispute. All they're asking for is an end to exorbitant pricing, and in particular, an end to per-pound pricing. Because the towers don't weigh the truck and its contents. They use a max weight. And so if your cargo hold is empty, you're paying as if it's full. And that doesn't make any sense either. A lot of us are attorneys around the table here. We bill by the hour. And so a fair billable system is how much work did you put in and how long did it take? This bill doesn't set rates. It allows the towers to continue to set their own rates, but it requires the towers to put a rate sheet, to give a rate sheet to the state police, who are the ones who are already administering the towing program, because they come on scene when a big truck breaks down. So I just want to give you the context of where we are and why I feel so strongly on behalf of this bill.
Thank you, Senator Waldstreicher, for a very interesting and complete explanation, up to a point. So, and the point is where the trucker wants to get the truck and all the cargo out from the towing company and go down the road with it. So here's my hypothetical situation. The trucker is based in Oregon and is headed for Oregon. And the trucking company puts down 20% and then leaves with the truck and all the cargo, and goes to Oregon and never returns. And the other 80% that's owed is never paid. What does this bill do to protect the the towing company, who only got 20% of what they're owed? Let's assume they're not a bad apple. Let's assume they're a good apple. Yeah. And let's assume the trucker's a bad apple. So the trucker takes off for Oregon. How does the towing company get the remaining 80% that they're owed?
Well, it's the same way they'd get any other owed money that we've talked about in this committee for small claims court or other issues that we've addressed, right? Well, so
against a company located in Oregon who probably won't show up, and we'll get a judgment against it.
Yeah, so I didn't mean to imply that it would go to small claims court. My point is they do what anyone in those circumstances would do. First of all, this only applies for good faith disputes. So in your situation, the trucker who is absconding is not acting in good faith. And so the bill doesn't apply to them because they're not protected by a good faith dispute. There's no good faith dispute. They're just, shirking their other 80%. But if the dispute were valid and yet the trucker decided still not to pay, then the towing company would have the opportunity to seek redress the way anyone would seek redress where they owed money. So they had the opportunity to sue.
Has anybody thought of using a bond? I mean, I was a commercial lawyer when I practiced law. Bonds are very conventional in situations like this. If the trucking company has a good financial statement, it has a relationship with a bonding company, it can obtain a bond and post the bond for the remaining amount of money for cents on the dollar. So for a $100,000 bond, it'd be $1,500 maybe to get the bond, if that. all depending on the financial situation of the trucking company. And then the towing firm would have the assurance that the money would be there at the end of the day if the ultimate decision was that the towing company was entitled to the money.
I think that's a really thoughtful way to go about it. The problem that's happening here, and the reason this process has been so disappointing, is that the towers haven't come to the table to explore creative solutions like what you're saying. And so we're left with kind of one party saying, this is a fair system, and the other party saying, well, I don't even want to have that conversation, which is why this has been so disappointing, because if the towers came to the table to discuss these issues, I believe they could work it out. But in the absence of them doing so, we have to come up with something and move something forward. The House has moved this bill forward unanimously through their committee. And so they have similarly expressed frustration and decided at some point the Assembly has to step in and say, we think this is fair.
Okay. I just say I remain uncomfortable that the trucker's going to drive away having paid 20% of the bill and maybe to never be seen again.
Just a quick question process-wise. With the explanation, it's the state police who calls the tow company. How do they, is there some processes in how they decide, and are they just going down the list? Because I'm assuming they're going to see that somebody has higher costs than others, and I'm wondering what goes on behind the scenes. Is to pick me, or?
Yeah, to my understanding, they're just going through a list. Okay. So whoever's next on the list, and to my understanding, the list does not include rates. It's just
Gotcha.
like Jim's towing, okay, you did this one, the next one is Tom's towing.
Thank you.
Thank you, Mr. Chair. So this seems to me like landlord-tenant court for towing, because, because it seems like, you know, right. You know, somebody tows a vehicle, is held, you know, you want the equipment to be released for a percentage of what's owed, and the towing company has to get payment through a third party, an insurance company in this case, is what I heard you say. And it brings to mind a couple questions. One is, are the towing facility employees, are they actually contracted? Is a towing company required to pay these folks upon, you know, coming back there with the vehicle to drop off, which, again, in my analogy of tenant landlord, you got to put money up front and wait to be reimbursed. That's question one. Question two is, you talked a lot about max weight versus hourly rate. It's my understanding that when tow companies get deployed, they have to select the equipment in their repertoire based on what they perceive the need is going to be on the ground. And each piece of equipment has a different cost. And I'm not comfortable with trying to assign an hourly rate, not knowing what is going to actually be required on the scene. So I have those really hard questions, and, you know, I understand you've tried to reach out and there's been an impasse, but, you know, impasses happen. But I'm really uncomfortable trying to, you know, force feed an answer to this when I just see, you know, so many subtleties that I think need to be considered.
What happens on a local road? I understand, I think it makes a lot of sense to do the MDTA process, but what happens on just
On local roads, it happens county by county. So different counties have different policies.
policy?
With whether it's police or fire and rescue, whoever comes.
Okay. I mean, but who pays? I mean, they have to deal with the same issues.
Yeah.
Yeah.
And do they hold hostage on local roads too?
Yeah, but
I
you
mean, I
can-
assume.
You usually have a local tower and a local trucker on the local roads, so they just take them to court right then. I mean,
Okay.
the risk
Right.
isn't as great.
So, I mean, you do see big rigs on local roads, but it's usually just at the end. The majority of their time is going to be spent on state
the
roads.
state. Okay, thanks.
Yeah, I mean, I agree that it's a challenge. You know, when the fair market analysis doesn't quite work here, because if it's a fair market, I decide I'm going to hire a crane for my house to do something. I know I know where the crane company's coming from. They know where I am. And if I know I'm hiring a crane company from Idaho to come in, and if they screw up and they destroy my property, that's my choice. I knew I was getting a fly-by-night crane company, and they came in and did it. But I knew the risk when I took it. But that's not the case here. And as the vice chair said, this is a lot of small independent truckers, and that's the risk. If the trucking, if it's a, food fare truck, everybody knows there's money there. We can sue food fare. They do work everywhere. They're subject to lawsuit in Maryland courts and all that. They've got their assets here. But I think that Senator West's solution of a bond seems the obvious one to me, because if there's, the cost of the bond will depend upon the financial viability of the truck, the truck owner. And if they do business everywhere and they're a recognized minimal risk, their bond will be minimal. But if you're a small international trucking company that's kind of passing through Maryland on your way from Mexico to Canada, and you're a locally owned person, the cost of the bond will reflect that we have no idea where you are. So it will reflect the risk that the trucking company is undertaking as well. Giving the insurer for the cargo, I'm not sure what they get you, because the cargo owner wasn't negligent. They just gave you a trailer full of cargo. Any negligence, I guess that they could have given you a faulty trailer, but that's not too often. The negligence is going to be by the guy driving the tractor, not the trailer. And so you sue the cargo owner. He's going to say, I didn't do anything wrong here. You just hauling my stuff. So there is a problem here, and it's got to be addressed. I would feel much more comfortable if the solution was what Senator West suggested, which I think is a great solution. You want your truck? And another problem is the bill talks about a genuine dispute. You don't know about a genuine dispute till you're in court. Any dispute can be genuine. Anyone can be illegitimate. Nobody's going to know if there's a genuine dispute until you walk into court and the judge says, that's a genuine dispute. Somebody wins or somebody loses. So, we got to do something, but I really think to say, well, the truckers didn't come to the table, that's not I'm just troubled, because I got to protect both sides. And I've got trucking companies and I have towers in my county, and I like them all, but it's got to be a fair solution. And, we talk about the local people. They all know each other. They're going to work deals out, because the local guy needs to be towed in Maryland and on local roads all the time. So he's going to have some good towers. He's going to have a relationship. You don't want to piss them off, because what goes around comes around. It's this multitude of local independent truckers that's the concern, who can walk from their debt, and that's somewhat concerning. When it may have been a $50,000, $60,000, $80,000 tow, that's a lot of money out of a small, a local tower's pocket. So that's my view.
So, I've actually, way down in St. Mary's County, we've had this a couple times where we've had to deal with this. I remember one of them was, I had one of my people that runs a big produce farm. They had bought a trailer load of produce, and sure enough, the accident was up on the Beltway, and the truck was impounded, right? The truck was towed, and they said, well, until you pay it. But the guy that he wasn't the trucker. He just had the load of produce. He'd already had to buy the load of produce, so they wouldn't release the load of produce, right? Because they said until it's paid for for the truck, it's all impounded, right? So, they went up and stole the produce back, right? And got it, because they were like, we can't lose all this money and it'll go bad while this is negotiated. And so the other thing is, I got this currently going on with some businesses down my way as we get more populated. We've got a lot of state roads, and they're got tractor trailers coming in to load and offload at businesses in the morning, so they block the state road. They sleep there overnight. You've got dual lane highways that are shut down to one lane because of the tractor trailers sleeping at night, waiting to go into these big commercial businesses. And so I contacted the state police and said, hey, what are we going to do about it? And the state police really refused to do anything. They went there and they talked to the truck drivers. Well, they didn't take the trucks, right? Because they said the expense of the tow is such a big deal that we'd rather not get involved in it. Right? So I'm like, well, we got school buses and everything else operating at the edge of daylight when these trucks are sitting here with all this traffic. It's a danger. We're gonna have to do it. Fortunately, the sheriff's department went ahead, exercised it, and took care of it, right? Once they took a couple trucks, it was no longer a problem. They found out they couldn't block the state roads like that. But the issue was dealing with the towers. If MTA has a regulatory process that works, why don't we just adopt the exact same process and force the state to do those same regs?
I agree with Senator Bailey that that is the path forward here, and that's what the legislation was designed to do as it came in. And to the extent that there are amendments, they only go away from the MDTA idea in order to try to assuage the towers. Let me just say one thing about the 20%. So I agree that this could be a theoretical issue, but most of these truckers are, they are, because they're going between states, they are federally licensed, they are highly regulated. The idea that they're going to go state to state and every time a tire blows out, they're going to pay 20% and keep moving and then just kind of rack up debts around the country, I think is not a realistic argument. These are really, I've had the opportunity through this process to meet a lot of these guys, to meet the association, which is out of Missouri, I believe. I mean, these are hardworking men and women who care deeply about their job and care deeply about safety, and they're committed to paying their debts. But sometimes these things are in legitimate dispute. And when they are in legitimate dispute, they need to have the opportunity to have a process to adjudicate that dispute and get their stuff back before doing so, so that they can A, deliver their goods, sometimes they're perishable, and B, continue to make money, because when they're not driving, they're not making money. And so, I agree that theoretically you could have a bad actor who is always paying 20% for a get-out-of-jail-free card. I just don't think that's going to happen in practice. I think the benefit of this bill outweighs the risk that there are kind of, folks who are just not going to pay their debts here.
So my question about the 20%, and I know from hearing from the towers that they were not happy with it, but from what I heard from the truckers, the towers really didn't make any type of good faith effort to come to the table, right? They said, this is what we're going to do or else. Is that right? I mean, there's got to be negotiations here. They've got to be willing to do it.
I want to get in a back and forth, and I haven't been in the room when these meetings have taken place. I don't have firsthand knowledge. But my understanding, and maybe you meant to say this, or maybe you is that that the towers have been not exactly forthcoming in their negotiations and saying where they think the appropriate line is. Because I imagine if the truckers said, we're happy to pay more, we'll go up to 25%, 33%, the towers will continue to refuse, that they want full 100% payment under any circumstances.
And the way, and the posture of your bill right now is for the 20%?
Is that 20%? Yep.
I would personally move favorable.
I mean, I listened to both sides. I thought both sides made good arguments. And to be honest, I hate being in the middle of industry arguments. When they can't work it out, they come to us to try to have us work it out. And it seems to me they're down to 2 points that they can't resolve, which is the cargo issue and the per pound. And quite frankly, I think Center West, even the idea of just bonding it, I don't like the idea of like, we take our stuff and give you a deposit. That seems to be, that's all you're ever gonna get possibly. Like, yeah, you can track them down in court, but after everything we were doing on body attachments, everything else, it's harder than you think to get people to pay in court. And then the per pound, I have no idea. I'm not a trucker. I'm not a towing guy. Actually, I did drive a big rig, so actually I take that back in the military. So I guess I should be siding with them. But I have no understanding of how it works per pound, what it costs, and they're talking about these trucks going down ravines, and I have no kind of idea. That's not my area. None of us know this. They're down to 2 points. And where's the House on this? I thought they were moving something.
They are moving, they moved the bill through committee unanimously,
They moved it through unanimously. And
as amended.
and did theirs deal with the cargo and per pound issue, or is that still a fight amongst?
They took these amendments, so
They took these amendments,
Yeah.
but even their amendments they have, they're still the sides don't agree on. So we're gonna get a House version, it's gonna come to us. My preference is to hold this and have these two continue to work it out, because quite frankly, I know finance, we don't get this as much. You know, it's the ophthalmologist and the optometrist, or they had the dentist wars and all that stuff. I just personally don't like that. And we're gonna get to the floor, and then we're gonna have one side or the other get up and blow it up and fight it. And I don't wanna be up on the floor trying to argue per pound towage when I don't know, and I doubt anyone on this committee knows it. So I just suggest we hold it. They're down to two things left. Let them try to figure it out.
All right, Senator West, if you want to chime in, and Senator Watson, but we're going to hold, I'm going to hold the bill. Senator's asked for a hold, we're going to get a hold, but.
I was going to agree with Senator Huff that the bill should be held. We will have a hearing when the House bill comes over. I would hope that the towers and the truckers would take a look at this bond suggestion prior to the hearing, because I think that's the easy answer, which should get everybody on board. Maybe they've never heard of bonds, but they ought to get someone who works for a bonding company to come and give them advice as to how a bonding solution would work in this situation.
I mean, we came to this 20%. I mean, 20% of what? I mean, how is that even derived? So my question is, when a towing company is alerted that there's a need for them, are photos taken of the scene? Is certain information given to the tow truck so that they know what type of equipment to deploy? And if so, can you somehow negotiate an hourly rate based on the weight of equipment deployed versus some arbitrary hourly rate that I don't know where you're going to come up with? And I think that would be the best, to me, starting point to ensure that there's a recognition not just of hourly weight, but of the intensity of equipment that has to be deployed based on the unique circumstance. And I think that's what I'm held up with. There's a lot of work required. It could cost $100,000 to go ahead and do what needs to be done, and you're going to give me 20%. You want me to be happy and go through another third party to be made whole. How long? I mean, that's my sticking point on this. So I hope that's taken into consideration.
All right. We're not going to, I want to add an amendment to a bill, Josh, for Senate Bill 670. We're not going to vote on this right now, but I just wanted to discuss the amendment and add it, and then it'll be before us next time we vote. 670.
So the additional amendment would be on top of an existing amendment, which is in your packet. It's number 893923/1. On page 2 of 3 of the reprint, in line 15, in the new subsection B, it would now read, this section does not apply to 1, Class L historic vehicles, or 2, any vehicle required to be inspected under section 23-302 of this title. The idea is to take out commercial vehicles which are already required to be inspected and have preventative maintenance done either once a year or once every 25,000 miles.
We have an older amendment, right?
So you have, this would be on top of the amendment you have in your packet, yes.
And you're talking about page 2, after line 20?
Page 2, line 15.
15.
Where it does not apply to Class L historic vehicles, there would also be this additional carve-out to the bill.
I'm sorry, could you read it again?
So it would now read, this section does not apply to 1, Class L historic vehicles, or 2, any vehicle required to be inspected under section 23-302 of this title, which is the commercial vehicle inspection program.
Okay. I don't remember the bill.
Would this apply to farm vehicles? Vehicles with the agriculture exemption farm tags, farm use?
Yes, as long as it did not as long as it doesn't go through the preventative maintenance, which I probably would not.
So that means they'd have to get an inspection every 5 years for a farm vehicle that they don't pay tax on or and just use to go across the highway from one farm to the next?
Correct, if it's registered as a farm vehicle, yes. It is not.
So, there's another amendment.
Right.
All right.
We-
Vehicle is?
So a historic vehicle is at least 20 years old, not substantially altered from its original form, and generally not used for transportation on public roads.
Well, so what does that mean? I mean, I go to a lot of these car enthusiast places, and there are a lot of cars, technically speaking, that are over than 20 years old, and people get a lot of, feel very good about having their old restored cars. They have to drive them to and from certain places to show them off. When you say not typically used, to me, it's another exemption for those at the higher income strata who do these things for their own personal enjoyment and not be held to the same standard because they have an operating motor vehicle that traverses our road, whether once a day or once a year. I don't think that doesn't pass the smell test for me.
Yeah, so just to clarify, the way that it works is when you submit the application for a Class L registration, you have to certify that the vehicle will not be used for general daily transportation, primarily for the transportation of passengers or property on highways, for employment, for transportation to and from employment or school, or for commercial purposes.
So it, in effect, sits in somebody's showroom just to be displayed
All right.
as a historical
We're gonna
piece.
just-
Correct, and you could maybe occasionally drive it, but not,
Okay.
as long as it wasn't general daily transportation or primarily for that purpose.
We got one more.
Thank you.
We'll hold this for further review and work. We got one more bill, which is Senator Lee. And this will be the last bill for the day. 816. Heather, go ahead.
So there is an amendment in your packet. It is amendment ending in 621. These are the same amendments that the House adopted. It's currently on third reading in the House. So the bill as amended, it requires the Department of Agriculture to develop a fact sheet to provide information to a tenant on how the person may care and protect any pets in the event that the individual is evicted or loses possession of their property. The fact sheet shall be also posted online and updated. The bill then goes on to require a landlord and a copy of the lease to provide a description of the fact sheet, not the actual fact sheet itself. That's one of the amendments. And where the fact sheet is located on the department's website. The bill also requires the judiciary to include a description, again, of the fact sheet with the, when the warrant is issued, or when certain warrants are issued. Again, the warrant will not actually have the fact sheet attached to it. That goes to address the concern that was brought up during the testimony, with the concern that the tenant is receiving too many documentations at the same time. So the amendment just requires a reference to the fact sheet. And then the bill, lastly, it deals with provisions for the actual eviction. So if the premise is inspected, there's a pet, which is a cat or a dog, under the bill that, and the tenant is there, the tenant is then placed in possession of the animal. If the tenant is not there, then the pet is then taken to animal control. It cannot be put out on the streets, and then contact information must be given to animal control or the shelter, excuse me, for the individual.
An eviction, they're just like,
Yeah.
nobody does that. Is that testified that somebody's doing that? No chance. People are doing that, they just open the door and let the dogs
Yeah,
run out
well,
the street.
probably some jurisdiction, some counties, there are people that do that. I wouldn't do it. So this says you can't just throw it out on the street,
The dog, yeah.
the dog or cat. And it only applies to domesticated cats or dogs, not any other pets.
The snake, I'd be really mad if like Frederick County was letting boa constrictors and just putting them out.
No, it doesn't apply to boa constrictors, so. It's a very streamlined bill now.
It just says if you're evicted, they have to give the animal to animal control.
the notice too. They're creating the fact sheet, Department of Agriculture, and posting that online. And then there's like specific points when the tenant would need to receive that the fact sheet exists. So in the lease, the lease needs to contain, here's a fact sheet you can look up on the Department of Agriculture's website that explains if you are evicted, here's how you can care for your pet. And then when the tenant is evicted, the warrant of restitution, or the warrant needs to contain a reference to go to the department's website if you have a pet to learn what protections are available.
I mean, if there's an eviction, the sheriff has to show up everywhere in Maryland, other than a commercial eviction. A sheriff has to show up to do the eviction. Well, I just have a bill that just, I'm sure they're all doing it, but maybe some sheriff's departments not, or office, just require that if there's any unattended animals on the site at the time of eviction, that the sheriff must either transport them to animal control or contact animal control to come pick them up. I mean, animal controls know what to do with animals of all kinds. I don't think tenants aren't going to read these things. I would hope sheriff's offices aren't just opening the door and letting the animals out, but if you want to pass a law that says they can't do that, it just seems like this is really a convoluted way of getting about this. And we know there's going to be a cop there because that's what's required under Maryland law. You know they're going to be there during the eviction. They can certainly see what's happening and then just either call or transport themselves if they want to. If it's a little kitty cat, maybe they'll just put it in their own car and take it over. Seems to be a lot easier way to go about this.
I think it just establishes process because there's some inconsistencies in different counties, how they handle this. That's all it does.
Specifies, this is on page 4, that if the individual's not present at the time that the property is delivered to the landlord, the sheriff, it would be, must contact animal shelter or animal rescue organization to take custody of the pet, is what the bill specifies.
Yeah, some counties already do this, but some do not. So we just want to have a uniform, consistent process.
That's fine. So why can't we just delete everything in the bill except that paragraph that Heather just read, and then it would be a good bill?
Well, Heather, I think all the parties came together, and this is what they agreed on amendments. Let me get I have not the answer yet. I don't know why they do it. Hold on just a minute, let me find out. Let's see.
Yeah.
The Department of Agriculture already maintains the list of all the shelters in the state, so it's to make sure that the one entity that has all the shelter contact information knows which shelters offer different services, and put together a fact sheet with the resources and the information for tenants that have to pay.
Stop the amendments. All right, that's fine. Senator Bailey.
So let me try to get this, because, so why isn't the sheriff in charge of doing this?
You know, because they're involved in the eviction process, usually.
What's that?
They're always involved in the eviction process.
Yeah, but but when we
When
deal
someone
with,
gets evicted, the sheriff goes to the premises.
we want to just hold this and we'll continue. Okay,
Well, Senator Bailey, why don't we talk after
that's
this,
fine.
okay?
Right.